Hello students, this is Supriya Mogle, Assistant Professor at Center for Distance Education, Shivaji University, Kolhapur, and I am back with one interesting topic of business law, that is Indian Contract Act 1872. So today we are going to learn what is the objective of Indian Contract Act, or what are the elements included in this act. What is contract, what is agreement, what is the difference between agreement and contract, what are the essential elements to be added in the contract, etc. And there are some types of contracts we are going to learn today. So let's start. First is introduction about Indian Contract Act 1872, which was inspired by the English contract law and passed on 1st September 1872. So first of all, you should know what is contract and what is agreement. So first, what is contract? Contract is, a mutual assent by two or more persons to one another, and it is made through some offer and some acceptance. That means, someone is promises to other person to do something, and in return that other person is going to do something for the first person. Maybe it is shown in the words, it is shown in the conduct, etc. That means there is one person is offering something to the other person, and at the same time other person is accept that deal. uh, for example, what is agreement? A promises to B to sell his laptop for rupees 25,000, and B accepts it to purchase it for the said amount. This is agreement. Okay. For example, we go to shop and we buy something, and in return when we buy something we are going to pay the amount for that product. Okay. And when we pay the amount of that product, the person or the seller is going to give the product in return because we have paid. This is agreement. Okay. It should not have some paperwork, etc. It is understanding. Suppose a little example, when we buy some milk in the morning, we go to the retail shop, we give 50 rupees and take one packet. Okay. So here we have given 50 rupees for milk, and the seller or the retailer is providing the milk in return of that amount. So that is the agreement. Then what is contract? So the contract is an agreement that is enforceable by law. Means any agreement when it has some legal formalities added in the agreement, then it is called contract. Okay. For example, a loan agreement between buyer and seller of a car. Suppose there is an agreement between a buyer and seller regarding a loan of a car. Okay. And suppose a person who is buying that car, or who is wants a loan for that car, he has to pay the amount of that loan with interest. Okay. And suppose he is not paying the money, or not paying the interest in return of that loan, then the other person or the seller can file a case in the court. Okay. So the buyer is liable to explain about it to the court. So this is called contract. In short, contract and agreement, the difference is, in agreement there are no such formalities of legal documents or legal activities, but in contract it is enforceable by law. There are some rules, there are some terms and conditions, some rules and regulations which are to be followed in the contract. Okay. So every agreement and promise enforceable by law is a contract. Understood? The next is agreement and contract. Every agreement is not a contract, but all the contracts are agreements. Okay. For example, we go to theaters, okay, we book a ticket and we watch the movie, and in return they show a movie for which we have paid, right? So this is also an agreement where both parties have that mutual understanding, okay. There is no such explanation, no such, words or statements in this agreement. It is mutual understanding. When we are going to theater and when we book a ticket, obviously simultaneously a person who is going to, give the service to us, he is going to show the movie for which we have paid the amount. So this is a this is an agreement, okay. And when we add some legal formalities to that agreement, these are the contracts. Now there are two types of agreements: social agreements and commercial agreements. So what are the social agreements? Social agreement, it does not need any legal formalities, and there is only understanding between those parties. For example, my father promises to give pocket money every month, so we have that understanding, okay. And suppose in any month my father is not giving pocket money for 1 month, at least for 1 month he didn't give me the pocket money. So it is not like that we are, we are not going to file a case against my father, right? So that is called social agreement. But in commercial agreement, in businesses, there are some contracts, means there are legal activities included in the agreement, means how many you are going to invest, how many how many people will be there in the company. If suppose one person is not investing in the company, then what is the use of that agreement? Or you can have a legal action against that person on the proof you have that contract. So when you have the agreement, you should add some essential elements and it becomes a contract. So in short, read the diagram: agreements plus essential elements is equal to contracts. Now what are these essential elements? Let's see. So, essential elements of valid contracts. First is offer and acceptance. So, what is offer and acceptance? There are suppose two parties. One party is offering something, and at the same time, the other party should accept that agreement. Means both the parties should agree the terms and conditions where one is offering and one is accepting. So this is very much important for valid contract. Then next is legal relationship. Legal relationship means agreements results in legal relations. If one of the parties fail to perform his promise, he will be answerable by the law. Okay, so agreements, when two persons have the agreements, there is a legal relationship, that is a contract, where legal formalities, the all the paperwork, the stamp, the legal papers are there, where both the parties have signed and both the parties have agreed on that particular deal. So there is a legal relationship between both the parties. Then free consent. Consent means what? Consent means that parties must agree on the same thing in the same sense, okay. Means one person is offering something, and it is to be understood by the other person and it is to be agreed by the other person, then only it is called free consent. Means consent is said to be free when it is not caused by coercion. Means it the consent should not be fraud or should not be coercion. Coercion means you cannot force somebody, you cannot force someone, you cannot influence someone uh, to have the contract or to agree something in the contract. So there should be free consent. Means both the parties should be free to take the decision whether it is to be accepted or whether it is not to be accepted. Okay. Then competent parties means a person who is, a important party of that contract should complete 18 years of age. That is competent parties. Lawful consideration means all the contracts must be supported by the consideration. And lawful object means it means the purpose or the design of the contract, it should be lawful. And it object is when it is said unlawful, when it is banned by the law. For example, okay, lawful object and consideration example. Suppose one person wants to kill somebody. Okay, there is one agreement, and one has given a contract to other person to kill that person. So it is not lawful. Okay, it is unlawful. And or one person wants to deceive other person in anything. He wants some money from that, and he is having false statement in that contract, and he is deceiving that person. So that is unlawful object. So in the contract, in the valid contract, the object or the consideration should be lawful. Okay. Or unlawful consideration, for example, someone wants to buy a prohibited item like gun. Okay, किसी को बंदूक खरीदनी है. So it is not lawful consideration, it is unlawful consideration. So in the valid contract you should have lawful consideration and lawful objective, not declared to be void. So what is void? Void means opposite to valid. Okay. Maybe, void means it is not enforceable by law. So that is called void agreement. Then certainty means what? Certainty means contract must be precise and certain. Means there should be possibility of performance, and agreement must be capable of being performed. Okay, by both the parties. Both the parties should perform that agreement, and there should be possibility of performing that agreement. That is called certainty, and it should be clear, it should be precise. So these are some essential elements of valid contracts. When we add these elements to the agreement, then it becomes a contract. Okay. So void agreements and voidable agreements. So what is void agreement? Void agreement means an agreement not forcible or not enforceable by law. Means not enforceable by law. The restraint may be general or partial. Party may be restrained from marrying at all, or from marrying on for a fixed period, or marrying a particular person or a class of person. An agreement is called void agreement. And what is voidable agreements? An agreement enforceable by law means there are legal formalities followed, and the rules and regulations as per the act are taken into consideration, so that are called voidable agreements. The next concept is free consent. What is a free consent? As I have said you, free consent means both the parties should be, should be free to take their decisions. And a consent is said to be free when it is not caused by. Not caused by means these the following point should not be there in the consent, then it is called a free consent. Means coercion means you cannot force somebody to include in the contract. Okay. Or you cannot what do you say, you cannot force, you cannot influence, under influence, you cannot influence somebody to take this agreement, to agree on some particular item. Or fraud means false statement should not be there. Mispresentation means to intend, he has some intention to deceive the other party, that is called mispresentation. And there are a false statement included in the agreement, or mistake means both the parties to an agreement are mistaken means suppose one person is not understood the terms and conditions, or one person who is offering the term, he is having a mistake in the contract, or anything, false statement is there. So if these points are included in the contract, then it is not set free consent. So these points should be avoided, then only you can say it is a free consent. Next is contingent contract. A contingent contract is a contract to do or not to do something if some event collateral to such contract does not happen. When the contract is dependent on conditional upon the happening or non-happening of a certain future event, the contract is contingent. Means what, a contract to do or not to do something if some event happen or not happen. Means suppose a person, there are two parties, A and B, okay. A person contracts to pay 20,000 to B if B's house is burned, okay. अगर there are two parties A and B. वहां पे उन्होंने एक कॉन्ट्रैक्ट किया है जहाँ पे अगर B का हाउस जल जाता है तो ए पार्टी क्या करेगी, उसको 25,000 रुपीज पे करेगी. सो दीज टाइप ऑफ कॉन्ट्रैक्ट्स आर इंक्लूडेड इन द इंश्योरेंसेस, ओके. इंश्योरेंसेस में आपको पता है कि किसी की डेथ हो जाती है, या फिर किसी का हाउस जल जाता है, किसी की प्रॉपर्टी को कुछ नुकसान हो जाता है, तो इंश्योरेंस कंपनी उसके बदले हमें एक फिक्स्ड अमाउंट पे करती है. सो दीज कॉन्ट्रैक्ट्स आर कॉल्ड कॉन्टीजेंट कॉन्ट्रैक्ट. अगर वो जो डील हुआ है, वो जो कॉन्ट्रैक्ट हुआ है, उसका जो ऑब्जेक्ट है वो अगर परफॉर्म होता है, अगर नहीं परफॉर्म होता है, देन दीज कॉन्ट्रैक्ट्स आर come into the consideration. So this is called contingent contract. Then next is discharge of contract. What is discharge of contract? Means a termination of contracts or contractual relationship between the parties. जहाँ पे contract खत्म होने वाला है, that is called discharge of contracts. When it is going to be discharged, first is by performance. By performance means when both parties have fulfill their promises. अगर एक पर्सन को दूसरे दूसरे जगह पे कुछ सामान पहुंचाना था और उसने वो पहुंचा भी दिया, तो वहां पे क्या होता है, दोनों पार्टी ने क्या किया, अपना अपना जो काम था, एज पर द एग्रीमेंट, एज पर द कॉन्ट्रैक्ट, दे हैव परफॉर्म्ड देयर ड्यूटीज. सो व्हेन दे परफॉर्म देयर ड्यूटीज, इट इज गोइंग टू टर्मिनेट द कॉन्ट्रैक्ट. देन ब्रीच ऑफ कॉन्ट्रैक्ट, व्हेन वन पार्टी promises other party, okay, in the contract, when one person promises something to other party and other party accepts that, then there is a contract. But what is breach of contract? As per the conditions, as per the promise, someone is not performing that duty, then there is discharge of contract. Then impossibility of contract means we have done some contract, we have included the terms or the rules and regulations, but now it is impossible to perform. For example, one person has to deliver some goods to other person, but at the time he is dead now, and if he is dead or because of his death, it is not going to happen, the contract means he is not going to perform his duty, so there is impossibility of contract and it will lead to have discharge of contract. Discharge by agreement and novation. So suppose there is any new agreement replaces the existing agreement, or maybe two parties have the mutual understanding or the agreement that you are going to terminate this contract, then you can discharge the contract. The next contract is quasi contract or quasi contract, whatever you pronounce. Quasi contract means what? Meaning it is not a real contract and imposed by law on the ground of principle of equity, and it is not created by an agreement. See, when one person has done something for another, or he has paid money on his behalf to the third party, the court comes forward on the ground of equity, saying that the person receiving the benefit must make compensation to other. That means, for example, someone has brought a suitcase which has full of money and he has to give to your neighbor, but he delivered to your house. So it is your duty, it is your moral responsibility to do not consume it. And when your neighbor comes, you have to deliver that suitcase, and it is your what? It is your responsibility, it is your obligations. Okay, so these type of contracts don't have free consent, don't have any consideration, don't have offer and acceptance, then also it becomes a contract. That means here essential elements are absent. Okay, uh, मैंने क्या एग्जाम्पल दिया, अगर फॉर एग्जाम्पल पिज़्ज़ा डिलीवरी, हमने कुछ ऑर्डर किया है, पिज़्ज़ा ऑर्डर किया है, और उस पर्सन जो डिलीवरी बॉय था उसने क्या किया, हमारे घर में डिलीवरी देने की बजाय किसी और के घर में वो डिलीवरी दे दी। और यहाँ पे क्या हो रहा है कि जिसके घर में वो डिलीवरी हुई है उसकी, उस पर्सन की वो मॉरल ड्यूटी है that he should deliver it to the right person. He should not enjoy that duty or enjoy that service because you have paid for that service. Okay, आपने उस पिज्जा के लिए कुछ पेमेंट किया है, तो अगर वो पिज्जा किसी और के घर में जा रहा है तो उसका, उसकी वो रिस्पॉन्सिबिलिटी है कि वो पिज्जा आपके घर में दे दे दे। और सपोज ही हैज enjoyed दैट पिज्जा, अगर उसने वो पिज्जा खा लिया तो उसके भी उसकी रिस्पॉन्सिबिलिटी है कि जो भी उसने पैसे उसके पैसे जो भी लगते हैं वो आपको उसने देने हैं। So that is called quasi contract. So there are some types of contracts. The Indian Contract Act deals with the following quasi contractual obligations. First is claim for necessaries supplied to a person incompetent to contract. Incompetent means what? Unsound person or some minor person. Okay, for whom you have helped him, means suppose one person has helped one unsound person or some incompetent person in terms of necessary items, आपने उसको इन टर्म्स ऑफ नेसेसरी आइटम्स आपने उसको क्या किया है, हेल्प किया है। यू हैव सप्लाइड दैट आइटम्स दैट नेसेसरीज, सो इन रिटर्न यू शुड गेट समथिंग कंपेंसेशन। अगर आपने किसी की मदद की है, इनकम्पिटेंट पर्सन है, अनसाउंड पर्सन है, माइनर है, उसको आपने कुछ नेसेसरी आइटम सप्लाई किया है, तो उसके बदले में आपको कंपेंसेशन मिलना चाहिए। कि कौन देगा? वो इनकम्पिटेंट पर्सन आपको कंपेंसेशन देगा, बिकॉज जो भी आपने नेसेसरीज उसको सप्लाई की है उसके लिए आपने खुद पैसे खर्च किए हैं, तो उसके बदले में आपको क्या मिलना चाहिए? कंपेंसेशन मिलना चाहिए। रीइंबर्समेंट ऑफ मनी पेड ड्यू बाय अनदर। सो रीइंबर्समेंट, if a person makes the payment which is the legal duty of another person, in such cases a person who makes the payment can recover such money from the person who is legally bound to pay. For example, आपका आपके नेबर में एक अंकल रहते हैं, उनको किसी को पैसे देने हैं लेकिन उनके पास अभी पैसे नहीं है, तो उसके बदले में आप क्या करते हैं, आप उसकी तरफ से जो भी कर्जा है, जो भी लोन है, वो आप पैसे दे देते हैं। और इट इज अ ड्यूटी ऑफ दैट नेबर, ऑफ दैट अंकल, दैट व्हेन ही गेट्स द मनी, उनके पास जब पैसा आता है तब उनकी वो मॉरल ड्यूटी है दैट आपके जो पैसे हैं वो वापस दे दे। सो दैट इज कॉल्ड रीइंबर्समेंट ऑफ मनी पेड। ऑब्लिगेशन ऑफ पर्सन एंजॉइंग बेनिफिट ऑफ नॉट gratuitous act. Not gratuitous means what? Not free. Okay, for example, if you have ordered something and delivery boy delivered your order to your neighbor because you were not available at that time. Now neighbor has enjoyed that product and used that product, so it is their moral duty to give compensation to you because you have paid for that. Okay, the product which is enjoying by other person, you have paid for that, so it is their duty to give the compensation. Then responsibility of finder of goods. Okay, finder of goods, suppose if a person finds certain goods belonging to some other person, in such cases the goods do not become the property of the finders. अगर आपको कुछ एक बैग मिलती है जहाँ जिसमें पैसे है या फिर कुछ गुड्स है, you are a finder of that goods, but it is not yours. Okay, it is your responsibility that you should give to the right person. अगर आपको right person पता नहीं है तो एटलीस्ट आप क्या कर सकते हैं, पुलिस स्टेशन में जाके वो सामान आपका नहीं है किसी और का है ये बताकर आपकी ये रिस्पॉन्सिबिलिटी बनती है। जब आप पुलिस स्टेशन में वो सामान देते हैं तो यू नो इट इज नॉट योर्स। ओके, आप उसकी जिम्मेदार नहीं होते तब। सो इट इज योर रिस्पॉन्सिबिलिटी, जब आपको कुछ ऐसा सामान मिलता है जो आपका नहीं है तो आपको वो उस राइट पर्सन को देना चाहिए। देन लायबिलिटी ऑफ अ पर्सन गेटिंग बेनिफिट under mistake or coercion. Suppose if a person to whom has been paid or anything delivered by mistake or coercion must be repaid or returned. ओके, मैंने जो एग्जाम्पल दिया था पिज्ज़ा का, अगर उसने वो इंजॉय कर लिया है, अगर उसने उसकी बेनिफिट्स यूज किए हैं, तो यू कैन नॉट यू नो यू कैन नॉट फोर्स समबडी, और फोर्सफुली अगर किसी को आप कॉन्ट्रैक्ट में इंक्लूड करना चाहते हैं तो इट इज wrong by the law. Or if a person to whom has been paid or anything delivered by mistake under coercion, तो they must be repay or must be return it, उसको रिटर्न करना ही पड़ेगा. So these are some quasi contracts. Then breach of contract. Breach of contract means if a person refuses to perform his respective obligation as per the contract. In an agreement, in an contract, there is some understanding. One both the parties have to perform something, and suppose one party is not going to perform, he is refusing to perform, then there is a breach of contract. When one of the parties make a breach of contract, the following remedies are available to the aggrieved party. So what is aggrieved party? Suppose there are two parties A and B. A को क्या करना है, बी के यहाँ कुछ सामान पहुंचाना है, और ए ने अगर वो सामान नहीं पहुंचाया है तो बी वांट्स टुडे। ओके, बी को अभी चाहिए वो सामान लेकिन ए से नहीं आया है, तो बी क्या है, एग्रीव्ड पार्टी है। तो उसके बदले में एग्रीव पार्टी के यहाँ कुछ कुछ राइट्स होते हैं जो परफॉर्म वो कर सकता है। तो फर्स्ट इज डैमेजेस. डैमेजेस मीन्स वॉट एवर द डैमेजेस सफर्ड बाय द एग्रीव्ड पार्टी, ही मे फाइल अ केस अगेंस्ट द फर्स्ट पार्टी. Then quantum merit. Suppose one person is agreed to do something or to complete particular work, but he has completed only some part of it. Means 100% काम करना था लेकिन उसने सिर्फ 30% काम किया है, तो उसको 30% का ही क्या मिलेगा, अमाउंट मिलेगा. एंड स्पेसिफिक परफॉर्मेंस मीन्स सपोज आपको एक ऑर्थोपेडिक सर्जन की ज़रूरत है आपके हॉस्पिटल के लिए, और उसके हिसाब से आपने कॉन्ट्रैक्ट किया है, लेकिन आपको ऑर्थोपेडिक सर्जन नहीं मिल रहा है, किसी मेडिसिन का पर्सन अगर उसमें आ गया, तो दिस इज नॉट हैपनिंग एज पर द कॉन्ट्रैक्ट. You have agreed to get professionals or specialists to do the work as per your requirement. It is not happening, so there will be breach of contract, as you can file a case against him. So this is called breach of contract. Okay. So here we are completing the Indian Contract Act. I hope you understood. Thank you.